It meant so much to him. I know he considered this only right as she being chosen to fill the vacancy. Loretta and I send our condolences to her and Lindsay's family and the legion of friends in South Carolina and literally around the world who worked with this great man. I'm going to miss him. Thank you, Mr. Chairman.
Thank you. Senator Tillis for an opening statement.
Thank you, Mr. Chairman. And I want to echo everything that's been said about Lindsay. He was a great man. Mr. Chairman, you may not realize this, but in some respects, Lindsey Graham's sort of responsible for this hearing today, because it was in 2019, one of your former staffers, Ted Lehman, who became my chief, suggested that we reestablish the Intellectual Property Subcommittee, and Senator Graham authorized that. And the work of the subcommittee is now coming before the full committee for the first time. And Mr. Chair, I also have to say that I know that you may have some questions and concerns. You're still examining this legislation. I think it's a real testament to your leadership to be willing to elevate something to the full committee that you yourself are still trying to work through some of the issues, and I appreciate your leadership. You know, it's our patent system, as Senator Grassley commented, is a part of our founding. I mean, we're the first nation to enshrine in our Constitution this concept of intellectual property. And I actually believe it's one of the reasons why we have become the innovator that we are. We started out thinking that thinking was important, and then being able to take that thought and put it into something that the person who invested their time and treasure could recover. It's what innovation is all about. It was such a brilliant idea. And it's not lost on me that some of the founding fathers were inventors themselves, and I don't know if it was a combination of vision or maybe some self-interest there, but either way, we got it right, like so many things in our Constitution. But the problem that we have with patent eligibility today is that we are on the brink of losing our innovation advantage if we don't figure out that the world has changed since the founding of the Constitution, and that things that we could not possibly have conceived of need to be considered potentially for a patent. And PERA is not guaranteeing that you're going to get a patent. It's simply saying the world has changed. The jurisprudence is all over the place. 12 judges have lamented the fact that they even have to deal with it when rendering a decision. And other jurisdictions are looking at expanding and have expanded eligibility. Why would the United States fall behind? I am not requesting legislation that guarantees anything can get a patent. At the end of the day, what PERA is trying to do is simply open the aperture to what may be patentable. And so today, we get to take, what I was telling the witnesses beforehand, the debate club up to another level. In my committee, some of y'all may have figured out I'm not overly formal. And I think we're at our best when we're doing work groups and we're having an exchange between the thought leaders directly. And so at the end of this hearing, the chair has allowed me to chair it, and I believe the chair is going to be leaving. You four should be taking notes, or your staff, because at the end of this hearing, when everybody else is probably worn out, I will stay here and we will drill down a bit on topics where that interchange is so critical. Because I believe, regardless of what side of the issue you are on right now, there is a path forward. And we can help those who are concerned with changing the status quo, but at the same time have a remarkable impact on really stimulating and fostering creativity going forward with a very different way of looking at eligibility. And I look forward to this committee, the committee hearing, and to your feedback. And Mr. Chair, again, I appreciate you holding the hearing. Thank you all.
I want to introduce our distinguished panel. I apologize. I was told you didn't want to speak. Please proceed.
Have you met a senator who doesn't want to speak? Mr. Chairman, thank you for your graciousness, and to you and Ranking Member Durbin for your long and deep friendships with Senator Graham. I had the blessing of having dinner with him last Wednesday night in Ankara with some of our staff. He talked about how excited he was for this coming Congress and for the way we might continue to do good things together legislatively on this committee and on others. My chief counsel just reminded me he was my lead co-sponsor of a bill signed into law by President Trump earlier this year, not widely remarked, but that extended the terms of bankruptcy judges in my state, his state, and many others. We were at times fierce partisan adversaries, but we also at times passed some really significant legislation, whether it was in immigration or innovation, whether it was advancing our national interests or our core values. Lindsay fiercely loved this country, and I am excited that his sister, whom he dearly loved, will be filling his seat for the remainder of this Congress, and grateful that I had the blessing of knowing this remarkable man who described himself as simply a country lawyer, but so often with his brevity and his incisiveness and his incredible humor, got to the core of an issue and drove it forward. And then also, Senator Tillis, thank you so much for your incredible partnership on this bill and on this topic. It has confounded many efforts at clearing the underbrush and clarifying the thicket. As you said, about 15 years ago, the Supreme Court started weighing into an area, Section 101 patentability jurisprudence, that was previously relatively clear. There have been huge changes in technology. Every member of the Federal Circuit at some point has reached out and asked us for guidance. Solicitors General have repeatedly requested that the Supreme Court revisit patent eligibility, but they have refused, denying nearly 100 cert petitions. And this isn't an academic exercise, as Senator Tillis just laid out. Developments in artificial intelligence, in blockchain, in medical diagnostics, in 5G are patentable in China and in Europe and not patentable here. And I view this as critical for us to address in order to restore American leadership and innovation and to advance our national security. If the court won't clean up this mess, Congress needs to act, and that's why Senator Tillis and I have been advocating for PERA over many Congresses. We at one point had 50 witnesses over 3 hearings on the subcommittee. Senator Tillis has been tireless and determined. I'm grateful this bill has the endorsement, the support of Senators Hirono and Blackburn, and the support of many other members of this committee. And Mr. Chairman, thank you for elevating this important topic to a full committee hearing. And I so look forward to this hearing today, to these 4 very talented witnesses, and just wanted to close by thanking Senator Tillis for his tireless engagement on this important issue. Thank you, Mr. Chairman.
Thank you, Senator Coons. I have the privilege of introducing these witnesses.